exciting video. In this video, I often say this: defense attorneys, they have a tough job. These defense attorneys got to get in the mud pit and speak up for basically some of these people are downright criminals. Let's just call it. This gentleman speeding, flexing in a pedestrian area more per se, because it was a area of 35-mile-hour, zone. And he's doing 75, like 70 plus. Let's say 70 plus in that zone. A person doing the speed limit doing 35, he clipped that person. He ended up killing his passenger. Now he's in jail. And his defense attorney is trying to get him out of jail. And the prosecutor is saying, nah, leave him there, give him a high bond. He don't deserve anything for what he did because somebody lost their life. The guy snorted cocaine and smoked marijuana. He was high out of his mind. How do you feel about this? Let's put it in the comments. Let's dive into the content, and we'll see you on the other side.
Thank you, Mr. Littlejohn. All right, this is State of Michigan versus Kevin Littlejohn, case 24058838801. Today is the date set for a bond redetermination hearing. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Bill Wright on behalf of Mr. Littlejohn, who's here for bond determination hearing, Judge.
All right. Today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable in this matter. Mr. Reagan has the bond.
That's why Mr. Littlejohn's bond is currently $50,000 cash, GPS, and alcohol tether. Your Honor, my client's 47. I don't see any prior offenses, any prior drinking offenses. I could be wrong. I don't see any prior drinking offenses, Your Honor. He had a 1996 narcotic case. This allegedly occurred, Judge, in April 2023. The warrant was not signed until last week. It signed the warrant until last week, over 14 months later. My client, Judge, is receiving Social Security disability. He actually just came out of a wheelchair just recently, Judge. He hasn't been able to drive a car at all, do anything recently. He's on 6 different medications. But, Judge, I don't know of any prior DUI situations. Now, obviously, any case is unfortunate. This is not the venue to try the case, to talk about, we know what the allegations are. We know what they are, Judge. But I'm saying in terms of bond, I think that the court could use a less intrusive measure than $50,000 cash a year later. I think that obviously no drinking, no driving, whatever other conditions the court wanted to put, but I would request a personal bond in this case, Judge.
All right, thank you, Mr. Reagan. Ms. Coyle has the bond.
Your Honor, this bond is appropriate considering have an OWI death and reckless driving causing death. Yes, this is one of the backlog warrants, my guess, based on it just being issued. This defendant was driving 78 miles an hour in a 35 zone when he hits a Jeep that was turning left in front of him. It results in the death of his front seat passenger. I believe it was his girlfriend. He was driving while his license was suspended. It's only charged with OWI and reckless because it was an FCJ as opposed to an FAC. He does have a prior criminal history, which is a 1996 delivery, which he did prison time for. And I also note that he had another possession of marijuana in 2003. I do note a 2004 aggravated domestic violence, a 2012 domestic violence, MDP under 200. In this case, the light was green for the Jeep. And what's troubling is with toxicology results are a 0.182 blood alcohol level, positive for cocaine, positive for marijuana. The defendant's car 1 second prior to crash was traveling at 79 miles per hour, no braking, and 1/10 of a second prior to crash, he was still going 76 miles an hour as he was braking. Your Honor, this is a situation which he cannot, I don't care what his condition is, he got behind the wheel of a car drinking and had been doing cocaine as well as smoking marijuana. He was traveling at an excessive rate of speed and over twice the legal the limit in that area. It was a 35-mile-an-hour zone. He then crashes into a Jeep that had the green light and that he was traveling at excessive speed, Your Honor, and that it caused the death of somebody. This is a danger to the community, and that this is one of those things where people they make a choice whether to get behind the wheel of a car when they've been drinking. Not only was he drinking, he was ingesting cocaine and marijuana, and then he was traveling in an excessive speed. So these are choices, and that he can't make the right choice, that he can't do that at home if he's going to do that and stay there. But no, he chose to get into a motor vehicle and cause the death and potential death of others. He's a danger to the community. So I am asking, a tether's not going to keep him at home if he chooses to, and an alcohol tether, because he also had marijuana and cocaine in his system. So I'm asking for this bond to remain in place. He knows the system. He's been in the system since 1996. And so this is a case in which people make a conscious choice to get behind the wheel. This is no different than somebody firing a gun in the direction of somebody. It is a conscious choice. So I'm asking for all those bond conditions to remain in place, Your Honor.
And Judge, my only position, I do understand what Ms. Coyle is saying. I have a great deal of respect for Ms. Coyle, Judge, but when you talk about how serious this is, or allegedly is, it takes you 14, 15 months. You don't do anything. People don't do anything. They don't file a case. They don't, arrest my client. They don't lock them up. They don't do anything for 15 months. So, Judge, I think that this is all in perspective. Now, if we're at a trial, that's an excellent, excellent closing statement or even an opening statement. But we're just talking about bond here, Your Honor. And I'm just respectfully asking, at this point in the proceedings, he's innocent until proven guilty. There are a lot of things that have to come up and have to be brought out. And, and it's not the young lady who passed away. It's not her fault. I don't want to say that wasn't charged sooner. I don't know why it wasn't, Judge. There could be a various number of reasons, but I'm not, trying to say it's anybody's fault. It just is what it is. And over the last 14 months, my client had no problems, no issues with drinking, driving, anything that we actually know about. So until he goes to trial and has a jury of his peers decide what happens, I just think bond purposes, you could tell him don't drive a car, no drugs, whatever other conditions you wanted to put on. And then a jury will decide, whether he is innocent or guilty of whatever he's charged with.
All right. I've had a chance to review the investigator's report as well as view the history involving Mr. Littlejohn. And I got to put this on the record. I believe one of these cases I was involved with, at least at some stage. I know, I had when I worked for Wayne County as a prosecutor, I was involved with Mr. Littlejohn on a domestic violence case. I don't know the outcome of that case, but I do know that we take testimony as it relates to that. What I have before me is a horrible, horrible situation. And I have a situation where someone dies, someone related to Mr. Littlejohn, or at least associated with him, due to the actions potentially of Mr. Littlejohn. I have a toxicology screen that indicates that this person was not only have a high blood alcohol level of alcohol and marijuana, but also cocaine. Mr. Littlejohn's going to get his day in court. And if he is found guilty by a court of law, I hope every measure of justice is issued. As to this bond, I believe that we can keep the community safe without a cash bond. So I'm gonna amend this to $100,000 personal with a GPS tether and house arrest. Mr. Littlejohn, while this matter is pending, you can't leave the house, only for medical purposes only. Sir, you are not allowed to drive while this matter is pending as well. If you are caught behind the wheel of a motor vehicle, you are going to be remanded. Sir, your next date in this case is going to be September 5th, 2024, before Judge King. September 5th, before Judge King. That concludes the hearing.
Thank you, Judge.
Thank you.
The gentleman that's on Division 1, Camp 4, could you unmute and tell me your name?
Mark Anthony Kimbrough.
I heard Mark Anthony. What's the last name? Kimbrough?
Yes, sir.
All right, this is State of Michigan versus Mark Anthony Kimbrough, case 24058961001. Today is the date set for a bond redetermination hearing. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Celebrate on behalf of Kimbrough, Your Honor, who's here for bond redetermination.
All right, today is the date set for a bond redetermination hearing. Bond is set intentionally unaffordable. Mr. Reagan has to bond.
Judge, as to bond, you know, my client's 34, Judge. He does have some prior record dating back to when he was 18, Your Honor, to I believe 2009. He had a assault with intent to rob while armed, felony firearm case, Judge. He's employed now, Judge. He's 34 now. That was 2009, 2024, has 3 children. Works every day, Judge, at United Towing to support his family. This is a domestic situation, Judge. Now, obviously, reading the allegations in the investigator's report, very serious allegations. You know, it talks about complaining being slapped. It talks about complaining being choked. Now, obviously, these are allegations, Judge, that Mr. Kimbrough is going to have to deal with when he comes to court. I think that obviously a no contact provision between he and Ms. Brown is definitely in order. I think the magistrate placed that in order. Now, the only thing I see is a $75,000 cash bond. I don't know if there was a tether added. I don't know if there was a curfew added. But I would note, Judge, I think that in domestic situations, unless you have so many previous convictions for that, I think that, Judge, the court could use no contact provision with the personal bond and whatever other restrictions the court wanted to allow him to go to work. He works to support his kids and come to court and make his court dates, Judge, and deal with this case and face it head on. He has a court date in front of Judge King on the 30th of August. And so he understands that's where he's to be if the court allows him to be released on a personal bond with the other conditions the court wishes to add.
All right, thank you, Mr. Reagan. Ms. Coyle has to bond.
I'm going to use Mr. Reagan's reasoning in that it's not a domestic, but it's an assault with intent, armed robbery, felony firearm. So he put a gun to somebody to rob them, and he was convicted and did prison time for that. So he does have an assaultive record, and that he does prove to be assaultive. And here, Ms. Brown, the allegations are that he hit her in the face and the back with a closed fist. He slapped her, and he wouldn't let her get out of the house. He swung her by the hair to the floor. Officers did observe swelling to her head and face, bite marks on her back and her shoulder. Her injuries included a burst blood vessel in her eye from being strangled, a scratch on her hand, a bite mark on her left shoulder. She lost consciousness for 20 minutes. At the time, his father came in, saw her being injured, saw what happened. He told him to take her to the hospital, and which he did. And because she was 7 months pregnant with their child, and he took her to the Henry Ford Hospital and dropped her off, and then he left. So, Your Honor, he does prove to be a danger to the community as well as to Ms. Brown, that he obviously has no regard, he's complete disregard for her safety or her well-being or the well-being of the child that she was 7 months pregnant with, and he knew that. Your Honor, so for her safety, is safety to the community. The Magistrate White imposed a $75,000 cash surety bond, tether house arrest. I'm asking for that to remain in place, of course, with all the other no contact provisions.
All right, Mr. Kimbrough, I see that you had your hand up. Did you want to talk to your attorney? Tell him what you want to say, and then he'll put it on the record. I don't want you to say anything that would incriminate you right now. So I'm going to put you in the room. Hold tight.
Can you hear me now?
Yep. 1 second, Mr. Kimbrough, just join the breakout room when you get the prompt.
All right.
All right, Mr. Reagan, Mr. Kimbrough, you guys are back?
Yes, sir.
Mr.
Judge-
Reagan, anything else you wish to tell us?
Yeah, Judge, I just want to let you know that it's my understanding that Miss Brown it's not 7 months pregnant. That's
Okay.
I think I said 7 weeks. I'm sorry
I mean,
if I
that's what
said months. I
you
meant
said months.
weeks.
Yeah, they found out.
I'm sorry. My
7
my
weeks.
apologies. Sorry.
That's all.
They
That's
That's
why
all.
found
I
out
said he knew about it, because 7 months he would obviously know about it.
Right. He said he didn't have any idea until they were at the doctor and she was pregnant at all for 7 weeks.
No, that is very important information. So I appreciate you telling me.
Well, that's what she
so
said
this-
we knew,
this-
but
Yeah, this is where I'm at right now. I have a situation that's an assault, and I have an assault of history. The matter before involving a weapon, the matter in this situation, allegations suggest that there's a serious impairment of a bodily function, just as it's charged. I do believe that there's clear and convincing evidence that this person poses a threat to not only this complaining witness, but to the community at large. Bond and all conditions are going to stay the same in this matter. Mr. Kimbrough, sir, your next date is September 5th, 2000, strike that, August 30th, 2024, before Judge King, August 30th.
All right. Thank you for tuning in to this case. Like I said again, the gentleman, drugs are dangerous, man. They are dangerous. People love drugs, and I understand that that's a way of life that we are going to have to get used to. People love drugs. You got states who approve marijuana, and people going to push back on me. Oh, marijuana is not a drug. It's a drug if you can't live without it. If it becomes a vice of your life, it's a drug. And fight me on it. And also, it's a gateway to different avenues of the drugs. Oh, this weed only going to get me to this high, but I want to be this high. So now I'm going to snort cocaine, or I'm going to do crack. I'm going to do smack. I'm going to do ice. I'm going to do ecstasy, or whatever I'm going to do. I'm going to pop a perk or whatever. Drugs are dangerous. And most of the people that get in drug is constituted with drugs. It's like a compound interest, because the drug is going to cause you to do something, right? And people are like, oh, alcohol, this legal. But if you can't live without it, it became your drug. But put it in the comment. That's enough of me rambling, going back and forth. Unfortunately, his passenger lost their life. And I know their family is not too happy with this guy, because I wouldn't be. And one thing I'm going to tell my daughter, baby, if you in a car and somebody driving crazy, tell them to pull over. Do not tolerate disrespect. Your daddy is coming to get you. And unfortunately, this guy was doing 70 plus in more or less a residential area, because it was only 35 miles per hour. But nevertheless, let's thank you for tuning into this video. You can support the channel through Cash App, Super Chat.